Lasting powers of attorney have been around now since 2007 and will allow somebody to have a say as to who looks after their affairs if they suffer from mental or physical incapacity in their lifetime. So this subject often comes up when they're preparing their will, but it's completely separate from their will. It's a separate deed that says if you suffer from incapacity at some point during your lifetime, you've named who can help. The process is that you can ask a firm to prepare your lasting power of attorney, and they will then oversee the signing and witnessing of the document. They may also sign that document for you to confirm that you have mental capacity now and know what you're signing, have a full understanding of the extent of the power of attorney. But the difference it can make is vast, in that if you've sat down when you're in a good state of health and said, if something goes wrong later, I appoint these people or this person, then all that person has to do, if you lose capacity, is register the document with the Office of the Public Guardian, which takes on average 6 to 8 weeks, and they can then have full access to your assets to protect you. They must keep a record of everything that they do, and they must act always in your best interest. But they can then, from that point, pay your bills, move your money around, work with your financial advisor, buy and sell property if necessary. So pretty much anything that you can normally do except gift money to themselves. So you're in a much better position then, as opposed to if you don't have a lasting power of attorney, your family or an appropriate person would have to apply to the Court of Protection in order to get themselves appointed as deputy. The process is much more time consuming and ends up usually being much more expensive. So you can avoid that process by setting up a lasting power of attorney. There's two types of power of attorney available to you. There is the power that deals with your property and finances, which is the one that I've mentioned, and there's also a version which deals with your health and welfare. So if you've lost your mental capacity, your attorney can help make decisions about your care. And if you're very sick, your attorney can make the decision as to whether to resuscitate you or not. In other words, speak up for you. If your preference was that you weren't resuscitated, they can then let the doctors know. If your preference is that you do want to be resuscitated, again, they can let the doctors know. So you're just providing your attorneys with the legal authority to speak up for you on your behalf until you recover or until you pass away, and then your executor would take over.